Did you catch that moment? The judge actually understands her frustration but still needs to keep the law in check. This is where empathy meets enforcement. The court can sympathize with a tenant's struggles, but financial contracts don't bend easily. Ebony's comment, "I could pay the whole thing but I'm not," hits hard. It's both defiance and exhaustion. What do you think, viewers? Is she standing up for herself or pushing her luck with the court?
2028. Okay, you paid that directly to that,
I paid that on
to the landlord.
Yeah.
On the
Straight to them.
24th. Is that correct? Okay, so what's our balance at this point?
$2,654.
$2,654, and then I have June clicking in tomorrow. So
I haven't said anything.
what's your monthly rent for?
1,028.
That's right. That's how we set that number. Okay. Okay, so this will keep us at the 20. We came down, but when could the June rent be paid? Do you know?
I don't know. I've been paying them almost every week. I can't afford to keep paying 1,028 twice a month.
No, okay, I got you. But so tell me what you can do. Because here's what I'm gonna do likely, because you got to get a mailbox key. I'm gonna put it out to the 14th. Okay.
Okay.
So what I guess I really was asking, between now and the 14th, what can be paid? Let's do it that way.
I can pay 500
500.
until I get paid on the 7th. So
500 on the 7th.
Mhm.
Okay, so I'll put 500 on the 7th. That'll work. I mean,
I could pay the whole thing, but I'm just refusing to at this point. They're not willing to reach out.
why?
I'm
You know
just-
what? She could have just let it slide.
I know I can't.
And I would have just let it just go. Like, all she's got is
This is-
500. Well, no, I could pay the whole thing, but.
But I'm not. But I've reached out to them several times about just, if you get the late fees off, I'd pay it in one
All right,
month.
listen, just
They
listen.
don't want to.
Oh,
Sorry.
no, I'm just gonna let you talk.
Thank you.
You ain't gonna let me.
Plus I walked here.
You walked here?
I walked here. So,
Okay, so here's the deal.
okay.
Get the 500 in. Can you? Is 1,000. Let me ask you, can you do 528?
I can even go, yeah.
Okay, I want to keep the numbers where I can. Okay, so pay the 520.
Now, as we move into the second case, meet Miss Tucker, another tenant caught in a legal maze. But unlike Ebony, Tucker isn't refusing to pay. She's fighting over who's responsible for court costs after what seems like a simple misunderstanding. This next exchange reveals how quickly miscommunication can turn a stable tenancy into a courtroom showdown.
28, so it's 5. I get your point. I mean, I make fun of it, but I get your point.
Yeah.
Okay. And so then I will adjourn this out to the 14th. Can we get our mailbox key?
Yes, Your Honor. Yes. And then Ms. Hobbs, you're contesting late fees or asking for a waiver of late fees. What amount of late fees? Like what amount?
They weren't, she just told me the late fees were out of the question to waive. So I haven't heard from her since then. So I'm just trying to figure out a fair amount where I can,
She said to you what?
that she wasn't waiving. They don't waive late fees, just go to court, is what she told me. And
So I have to.
absolutely, on the court.
So but with that being said, what amount are you asking for? Do you have an amount that you're asking for?
Not really, because I just got the ledger. like
You
yesterday.
correct me if I'm wrong.
Okay,
She is looking, really what she's saying, at least what I'm understanding is, I ask you to do certain things. You guys really aren't doing it. You're not paying attention to me. The only way I can get your attention is not paying. And so then when I finally get your attention, you want me to do that plus the late fees. So whatever late fees accumulated during that period, I'm trying to get your attention. I don't think I should pay, because all I'm really trying to do is get your attention. Is that just another way of saying it?
oh, great.
Yeah.
You go viral for this moment too. Perfect moment. Perfect.
Yeah, I'm just gonna be known as like the Ebony Hobbs Whisperer.
I swear.
All right. So that, and thank you for saying that, I guess, ma'am. All right. So with that in mind, I think council can look at it, maybe talk to Ms. Hobbs at some point in between and see if some resolution regarding that can come up. And then maybe we can just get this resolved so that Ms.
And
Hobbs,
that's really,
That's all I
Ms.
wanted.
Hobbs doesn't have to walk up here and
I do.
let me know that she walked uphill both ways.
I did.
All right.
Our phone number, our office phone number is on paperwork that you received under James Fink.
Okay.
In the end, both cases reveal the same truth. Communication is everything. Ebony's defiance came from frustration. Tucker's legal confusion came from silence. And both remind us how fragile tenant-landlord relationships can be when trust breaks down. The judge handled it with patience, fairness, and just the right touch of humor. If you found this courtroom showdown as revealing as we did, hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns every week. You won't want to miss the next one.
If you want to call that, once you look at the ledger, if you want to call that, make any sort of offer, then I can present it to my client and I'll communicate with them about the mailbox issue.
That's fine.
Thank you.
Okay. June 14th, 2024 at
3 p.m.
3 p.m. Tucker?
Hello, how are you?
Hello. So she was to file an answer by the 30th. Did you do that, ma'am?
No, so I got a call from Beth on Wednesday, this past Wednesday, the day before yesterday, saying that they had gotten an email from the attorney saying that we wanted to stay. So we talked about it. And then she talked to the owner and they were like, yeah, you can stay under these conditions. So I went up, my husband and I went up yesterday to sign the papers, but there was one stipulation in there that we hadn't talked about that I took issue with. And it was going to be too late because we went up yesterday to sign the paperwork. So she said that it was going to be too late for the dismissal, so that I needed to appear today anyway. So.
Let me clarify, guys. On Wednesday, I did receive an email from the property manager, Beth, letting me know that the defendants had an interest in staying on the property. So what we did is drafted a consent judgment with certain terms, about 6 conditions. And what Ms. Tucker is contesting is paragraph number 4, wherein we are asking that they pay the $218 in court costs as a result of filing this lawsuit, as a result of her staying and continuing to possess the property. And that's where we're at right now. I wasn't planning on dismissing.
So it's the 218.
Correct.
Okay. And what's your objection to that, ma'am?
My objection, which I explained to Beth, was that because what she told me, I was like, I don't understand why, if there was an issue, why nobody called me and talked to me. They just went to the lawyers, and the next thing I know, I'm getting paperwork, and she's like, well, they were just really upset. And I'm like, okay, that doesn't explain. So now you're asking me what happened. I tell you what happened. You're like, okay, that makes sense. We're going to talk, And so I told her, I felt that had they talked to us first, it never would have gotten to the point where attorneys were involved, and therefore payments would need to be made. Like those costs wouldn't have been incurred.
Okay. But here's the thing. They could have just proceeded, and then you take the risk of being evicted, right?
Well, yes.
Okay. So ultimately it all works out, but they have to, and certainly the attorneys, when they get the information and the authority to go ahead, they have to file the action. They don't have a choice. And they're just trying to protect their interest as you were trying to protect yours. If it came down to it, what would actually end up happening, and typical with most cases, is that you would owe the court cost. All right. I would hate to see a termination action all of a sudden get blown apart where the tenant gets to stay over 200 and some odd dollars in court costs.
I mean, I'm going to do whatever you say to do. I'm just putting my disagreement on the record is all.
Okay.
But either way, signing the consent thing wouldn't have, I was going to have to show up today anyway. So I was just verbalizing my disagreement with it.
No, I understand. I'm not criticizing you for it. I get what you're saying, but I'm not criticizing you by any
Right.
and please don't think that I am. I'm just I'm looking at it as I'm just looking at it as the practicality of it. I remember when you were here the first time, you were a bit shaken by the whole whatever, the whole thing that was going on. And sometimes, quite frankly, if people talk to each other, I would probably have half the work I need to her that I'm doing.
Well,
right?
well, yeah, it's just one of those situations where, you know, I've been a resident here for 15 years. There's never been an issue. So I was taken aback by the fact that they didn't bother to call me and be like, hey, what happened? You know?
Well, if I may, Your Honor, Ms. Tucker, I hope this doesn't happen in the future, but if it does and you're served with a 30-day demand, if I were you, I would utilize that time and go speak to management about that, talk to Beth, so that way a summons.
Well, yeah, and I had explained to her that because we had gotten the notification from the attorneys, I thought that I was obligated to communicate with the attorneys and not them, which I had sent a letter, but we didn't get any kind of a response. And so the next thing I knew, we got the summons and complaint. So that's, you know, so now I know in the future, I mean, I certainly don't expect there to be any issues in the future.
Okay.
But I do know.
All right. So when can you get that? When do you need time to get that paid? Or what?
Yeah, I mean, I wouldn't be able to make that payment until next Friday at the earliest.
So until the 7th?
Right.
Okay. So here's what I'm going to do. I'm going to enter that consent judgment. And the only pardon?
We did give her 10 days.
No, I know. And gee, how nice of you. But here's what I'm going to indicate, that the 218 has to be paid by the 14th of the month.
Oh.
Okay.
Okay.
What
That'll
is it?
give you a little bit of leeway.
That'll show up on the resident portal. I'm asking the attorney.
Oh,
I guess I should probably
will that amount show up on the resident portal?
I don't think so, but you will have to ask Beth, and I don't believe that she's here.
Yeah,
You can clarify
I'll
with
ask her.
Okay.
I'll just
Okay.
call her on Monday.
Okay. Real good. Anything else, Ms. Tucker?
No, Your Honor.
All right. So this is a consent judgment, and you would have 3 business days to think about it. If you think that there's some legal reason, some right you didn't assert, or some other confusion on your part, you'd have to file a motion with the court within 3 days of my signing the judgment.
Understood.
Okay?
Understood.
That doesn't mean that I would set it aside. It just means that
Right.
you would have that time to file that. Okay?
Right. Okay. Thank you.
All right. And Ms. Tucker,
Yes.
I'm going to tell you something.
Okay.
I appreciate you for feeling that there was something that you had an issue with and feeling comfortable enough to come to the court and voice your concern. I really do.
The legal
appreciate
arena is like a second home for me. Not on a defensor's side or anything, but that's what my educational background is in. So I'm very
Really?
comfortable. Yeah. Yeah.
Oh, I would have fought him then. No, I'm kidding. All right.
You know, if I had the time, I have a newborn grandchild. My daughter can't drive. I'm doing all the driving for her. They just moved. It's been crazy. So
Congratulations on the grandchild.
thank you.
Your Honor, before we go,
Okay, hold on.
ordinarily I'd request to obtain her consent to sign on her behalf, but there's 2 defendants. So
Oh, there are 2 defendants. Is
Yeah, well,
yes, there
because
is.
my husband, which he hasn't been able to, like, he works 2 jobs. He works afternoons and midnight. So he gets
Okay,
home in
I
about
gotcha.
just enough time to get some sleep and get up and go to work.
In the end, both cases reveal the same truth. Communication is everything. Ebony's defiance came from frustration. Tucker's legal confusion came from silence. And both remind us how fragile tenant-landlord relationships can be when trust breaks down. The judge handled it with patience, fairness, and just the right touch of humor. If you found this courtroom showdown as revealing as we did, hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns every week. You won't want to miss the next one. Welcome back to the courtroom, where one defendant's viral Zoom disaster turned into a legal roller coaster. Today, Judge destroys every false claim, exposing lies, unraveling excuses, and dropping a brutal truth bomb. This man never had a license. Ever. Grab your seat, because this courtroom is about to explode with receipts, revelations, and reality checks.
Signed off on?
It is.
All right, then I don't need to address. The public defender's motion to withdraw. I'll consider that withdrawn, given the substitution. I do have an appearance, and I will sign off on the substitution.
Thank you.
Thank you. All right, what are we doing today?
So, Your Honor, there's several options that my client,
Well, and I want you to know, counsel, that because of certain things, the court has a number of things I have to say.
okay,
Because I think the record, given particularly some of Mr. Harris's comments with reference to this court potentially acting what at least as I'm to understand is on what some may be, or is it, let's put it this way. People are saying, and quite frankly, your client has made the assertion that the Pittsfield Township, as well as this court, was acting on some type of defective or faulty information, which I will tell you, counsel, caused the court, given what the court did, to investigate what my ruling was. And I will tell you that that assertion is absolutely correct with reference to any faulty information that either came through to the Pittsfield Township Department of Public Safety or to this court ultimately at the May 15th hearing. And I think it needs to be stated, I've been asked for comments. I have refrained from comments, as is my normal practice is. This court with the pending case will speak on the record. And so I am going to make sure that the record is very, very clear as to what this court knows and what this court acted on May 15th. And we can start with this. And my basis for doing it is because of what was said about what this whole process was. And that an indication, counsel, and I know, counsel, you've been before me before.
Absolutely.
I know it is not coming from you, but you also know how I am.
I do.
And the thing is that if for whatever reason, the one time in my life I was wrong, I will say it and did. But when I'm not wrong, and when people are not to blame, then it also needs to be said. So I will try to get through this as quick as I possibly can. But I will tell you, first of all, with any reference to your client having had a license on that day, and some indication or misunderstanding as to whether or not he had a license, let me make it very clear, based upon what the court looked at, he has never had a Michigan license, ever, and has never had a license in the other 49 states and commonwealths that form up this great union. He has never had a license. In point of fact, when they suspended his license, and what people don't understand, when they suspended his license in Saginaw, they don't suspend the license. They suspend the privilege to drive in this state. Hence, for example, if he had had a Kentucky license, he would be able to drive everywhere that Kentucky would allow him to drive. He just couldn't drive in Michigan because his privileges had been restricted. I know you know that, but that wasn't at all said. But it doesn't matter because he didn't have a license ever. There is also then, and I will, when it is necessary, come to the defense of my sister courts, and I will come to the defense of Saginaw. They got a great chief judge. Chief judge answered the question. But I will tell you, that court and its friend of the court did nothing wrong. His license was, his driving privileges, better stated, were unsuspended in 2022. That required Mr. Harris to do something. He didn't do it. Therefore, that friend of the court was under no obligation to send anything to the Secretary of State. Now, I hated that I had to look at all of this, but when there's a question as to what I did, I'm going to look at everything to make sure that what I did was all in order. There's then an indication from that because that wasn't sent, there was a direct attack on Michigan's Department of Secretary of State's office, saying that the Secretary of State was somehow at fault. Let me tell you something. Secretary of State did what they were supposed to do. And in point of fact, they did nothing because they hadn't gotten anything from the court because Mr. Harris had not paid the reinstatement. This week, or the latter part of last week, once he paid that, Saginaw friend of the court did what they should do, and they sent it. Immediately, based upon the information that I have, the Secretary of State did what they do every day. They took that suspension off of his driving record, and he was then unsuspended. And then your client did what he needed to do with reference to the Secretary of State and paid a reinstatement. Just a second, Mr. Schiller. I'm going to let everybody respond because
Thank you.
I am not done yet.
Okay.
All right.
You're covering a lot of the points for me. Thank you, Your Honor.
And so that came down to that. So the information at the time that I had, that Pittsfield Department.
Now here's where it gets embarrassing. The judge confirms he's never had a valid driver's license. Not in Michigan. Not anywhere. The man's been rolling around for years on pure confidence and an ID card. When the judge dropped the receipts, it wasn't even a debate. It was a data-driven knockout.
When the public safety had was all correct at the time of both Pittsfield stop as well as the May 15th day. It was all correct. There was no error by anybody. It was a failure on the part of Mr. Harris to do certain things. Now, I grant you that sometimes that can be a complicated process, but it was certainly not anybody's fault that that didn't happen other than that wasn't paid. Now, here's the other thing, and I'm like maybe in church where I say I'm about finished now, but the other part of this is this stop was in October. Most of the cases that we've heard just in this last afternoon are driving while license suspended cases. That's part of my Wednesday afternoon. We go through great pains to try to get people their licenses back, which is really how it should happen. Between October and because I don't live under a rock, I actually watch things. You look very nice on TV.
Thank you.
You're welcome. There was something that was said that was very disturbing to me. And I'm just going to let you know because I believe in being fair with everybody. The question was asked along the lines between October of 2023 and the point in time of the May 15th hearing. Was there an attempt by Mr. Harris to correct his license? Here's the part that was disturbing for me, so that you know.
Okay.
Mr. Harris indicated that at some point he had been involved in some accident. And being involved into the accident that he was basically bedridden or at least housebound, he could not get to the Secretary of State. That was set up there. And I'm going to presume, because my knowledge of counsel, defense counsel is, I know you don't misrepresent anything.
Right,
You never do.
right.
That's not true.
Okay.
He purposely stated that he could not get to the Secretary of State, which, for the way we handle things in this court, would have placed him in a whole different category. We would have tried to find a way. Let's figure it out. And the reason I know that is because Mr. Harris, on December 28th of 2023, do you know where you were?
December 28th, 23.
23rd.
2023.
I know I was laid up from our
You
accident.
were at the Secretary of State's office. And you were at the Secretary of State's office because you redid and got your new Michigan ID. I have the date. That's the date you did it. December 28th, 2023. You did. And so that you also know, and in all fairness to counsel, because I don't know if counsel knows this or not, the way I know that he's never had a license is because May 3rd, 1990, he was 19 at the time. May 3rd, 1999, he applied for his first Michigan ID. Counsel knows, so I do. You cannot have both. You either have an ID or you have a license. One of the two. He has religiously every year gotten a new ID. And so he knows that he doesn't have a license. And quite frankly, I just wish he would have said that at the beginning. And all of this hoopla could have been just put all aside. And we all go through the process as we do with all of the people coming here to try to get him his license back. But his falsehoods, misstatements are not going to fare him well in this court. I'm done for now. I'm sure I will have something else to say. Whichever one of you would like to speak first, you may.
I'll wait to go last.
Yes, I spent yesterday at the Pittsfield Township Police Department with Officer Monaster, performing the traffic stop in this case. I also noticed the December 28, 2023 date, and I know the significance of that, and the court just went through that painstakingly, and I thank you for that. In addition, at the traffic stop, when I was at the police department yesterday, we watched body cam video. At least twice during this traffic stop, he acknowledged to the officer that he did not have a valid license. Quote unquote, quote, actually, I don't have a valid license, close quote. The question was, are you a valid driver? Quote, I am not, close quote. So, you know what, this is all this hoopla and the circus atmosphere is, in my opinion, is an affront to the justice system. I mean, I've been a prosecutor for more than 30 years, and to see this kind of hoopla around a driving while licensed suspended case is ridiculous. And it wasn't caused by this court. It wasn't caused by the Pittsfield Township Police Department. It was caused by the extra judicial statements made outside this courtroom.
Thank you.
Okay.
His lawyer tried the social media defense, said the viral video wasn't his fault, but the judge wasn't having it. She said he personally fueled that narrative, gave interviews, blamed police, blamed the court. And when she dropped the line, the person to blame is the one in the mirror. You could feel the temperature in that room drop 20 degrees. That's not just justice. That's accountability. Live on record.
So
Go ahead, counsel.
thank you, Your Honor. Thank you very much. Well, first thing I'd like to say is, very first thing is we're here and that we all saw this video. I wasn't in court. I wasn't even on YouTube watching the court today, right? I saw it because someone saw it and decided to post it. I can assure you that was not Mr. I don't think he has the capacity to be able to post it like that on YouTube or Instagram. So that was not him. And it happened to take off and go viral. So he had what we saw was him saying he was driving, which he should not have been driving, right? We're told not to drive on Zoom while doing that. So that's how this came to the attention, because the court, I saw you. He said, I can't believe this. Is he driving? And we all said that. Everyone who saw that video asked the same question. And that it became a joke. It became a complete joke. Now, with respect to what we want to do, and I cannot say anything is with respect to what my client has said, but when we talk about the hoopla, my client didn't start the hoopla. Perhaps he's made some comments, but he didn't start the hoopla whatsoever. That was someone that was outside of his control as to how it went viral. He had no control over that. And that I'm going to stand on that. He did not send it out to Instagram. He didn't send it out to wherever. He didn't do that part. So with respect to, did he have I don't want to try this case today at all, but what I want to do is focus on what's good. Now, what was good? That day in October, this officer here, that could have gone a whole other direction. And I'm so happy that you were so kind and courteous to my client. Thank you, officer. Thank you so much, because it could have gone another direction. We are here right now. My client has an appointment to go to the Secretary of State for his permit. He's working on that. I want to focus on how do we correct this and cure this? How do we go forward with this situation? Whatever, he was not under oath under any of the things that he said. So we're not talking about any type of perjury going on. Very true, right?
True.
So with that being the case, let's move forward with this. He is here. This is what I'd like. Because
Counsel, let me just.
Yes.
I would like to move forward too.
Yes.
On this case. We handle these cases all the time. But I will tell you, as you know, having appeared before me, the one thing I don't like is when people don't take responsibility for what they've done. When they take responsibility for it, we will use whatever we can to try to get you to another spot, because it doesn't behoove any of us for you to be in that spot. One other thing that I will say, when you say it wasn't started by him, it certainly was. It certainly was when he made his first statement to WXYZ about blaming people for this happening. And he shouldn't have done it, because when you look at the whole thing, the person that needed to be blamed, and we can go back to a lot of other points, but I'm not here to embarrass it, but the person that needed to be blamed is the person that he was staring at in the mirror. He didn't do what he should have done. And that's okay. The majority of people that come here on a licensing didn't do what they were supposed to do. That's like a given. They don't go about blaming anybody. They just say, Your Honor, I didn't pay the ticket. Your Honor, I just didn't do it. I just didn't have the time to do it. I just didn't take whatever.
Right.
Just own it. Once you own it, then it becomes a whole lot easier just to move forward. Okay, I'm sorry. I interrupted you and I said I wouldn't, but
I understand.
my court.
I know who you are, and I respect that. So, and where I am is where I've always been, because I can assure you that when he did speak to WXYZ that day, I wasn't representing him. I was representing him yesterday, right? And you would heard my message is that what steps are to correct this, and that's what I'm about, Your Honor. How do we correct this, right? I understand the entire process. I have not gone into detail, but I will take the word of the court and of Mr. Stiller here, brother counsel, and about the background and the history of it. But how do we go forward? And that's why I'm here to sort of minimize. You okay? Can he did get into an accident. May
He can sit
he sit
down.
down?
He can sit
May he
down.
please, Your Honor. Right behind, oh, well, hold on. Okay. And now that's real. That's a real injury.
I have no comment.
Okay. So what we're looking for, because there are some options here. My client has indicated to me and would like me to indicate to the court that he is in the process of procuring his license. Oh, hopefully that privilege will be available to him, but he does have, as you stated earlier, and I have the receipts. He did pay the reinstatement fee. Those fees are paid. Anything that was out in the previous court, those fees have been paid, and I've been presented with those receipts. In addition, on tomorrow, he's got his permit test coming up, and then after that, because he's an adult, he's working on it so that he can take advantage of the offers that are available, because as you say, this court does want to help. Absolutely. And with that, because my client was in an accident, and I haven't seen the medical records, but because of some of the things it could be, I don't know. But sometimes our memories get a little foggy. Now, am I going back to 1999? No, I'm not. But I'm just saying that I'm saying from this day forward, he is working diligently to take the steps necessary to get his driver's license so he can take advantage of the generous offer. Thank you.
Yes, ma'am.
Yes.
Yes, Mr.
I hate to say this, John, one additional thing. I think Fletcher Cox and I need to approach the bench. It may involve Mr. Allen.
Who's Mr.
I
Allen?
know, because I know what it is.
Okay, thank you.
Well, who's Mr. Allen?
That's my bailiff.
Oh,
I will give out whatever date I can.
okay.
Counsel, you probably didn't know this, and I wasn't sure where the prosecutor was going to bring. He's got a warrant.
No, I did not know.
Yes, he has a warrant for his arrest. A bench warrant out of
Allen Park.
Allen Park. Mr. Allen.
24th District Court.
Okay.
The shocking thing about it, for a driving while license suspended, that he didn't take care of.
Okay. Well, like I said, he
So-
wants to handle.
So
He's
what it
dedicated.
is that, and it's a valid warrant, I happen to be within their radius of pickup. Now, having said that, I don't know if they will pick him up.
Okay.
I will say that what should have happened, I'm not going to go through and try to figure out whether it did happen. But when he was arrested, when he turned himself in on my revocation of bond, upon being released, he should have been apprised, warned, and released to go take care of it. I don't know whether he was. I really don't care whether he was or not. All I know is that was back at mid-May, and it hasn't been taken care of. And it's still valid. I was hoping maybe that somebody was going to try and take care of it, because I'm sure if you had known, they would have been done. So much so that part of my delay in getting out of here was to make sure that it was valid. I had my staff run him right before I came out, so that if it hadn't gotten taken care of and in, then fine, we were okay and I didn't need to deal with it.
Right.
But it's still there.
Okay.
So will July 17th work as a new date for you to come back? Because as I understand it, he is right now not licensed. So if he goes in on Thursday, gets his permit, he's got to drive for at least 30 days. Apparently he knows how to do that part. Sorry, that was, I'm sorry, I didn't need to say that, but he knows how to do that part, but then he's got to go back, take the test.
Right.
And then he can do that. He may be able to accomplish it in that time, that 45-day period. If not, I mean, counsel, I just want him to have a license.
We all want the same thing. One moment. So the 17th, it may not be me, it'll be another attorney from my office who can.
Well, I don't
I'm
want
in
that.
trial.
I don't want that.
You want me?
Yeah,
Okay.
I know. You'll never hear me say that. But I don't want to go through this whole, you understand it.
Right. No, I get it. So I started trial on the 15th and
What's my date after the 17th?
August 7th.
What about August 7th? We can just put it out and then he can do what he's going to do or not do what he's going to do, but he should be able to.
August 7th at 1 o'clock, or would it be at 9 a.m.?
I will set it at 9. We will send an invite now that we have your appearance. So you'll get a direct invite from us as to what time block he's.
Okay. And then I just need one moment to talk to my client. You want to
Yes.
tell me something? Okay. August 7th at 9 a.m.
At 9 a.m. I'm going to take him into custody on the warrant. The only question that I have, and the way I look at the warrant, the bond looks like $500.
Okay.
Two things. First, I don't know whether or not they'll come get him.
Right.
If they don't come and get him, we'll release him. We're not going to hold him. If they are coming to get him and he's going to be held, the only question I would have for you, counsel, is do you want me to set a nominal bond on this so that he gets credit, or do nothing and not worry about it? I'll leave that up to you.
Okay. That will be, but absolutely, I want him to be able to get full credit for anything that is necessary.
So let's do it this way. If he's not, so I'm going to take him in. If for whatever reason he's not released tomorrow, call my office, and with the agreement, I will set a nominal bond
Okay.
on it rather than do it right now. So he has to deal with two things. So that you're also clear. Part of the reason I'm also doing this is because I think he was warned and released, didn't take care of it. And secondly, this has been out there for 9 years.
Well, I did not know about it, Your Honor. Okay.
Counsel, there is not a doubt in my mind that.
In the end, this wasn't about a license. It was about truth. A judge who checked her facts, a defendant who ran from them, and a viral moment that flipped from sympathy to self-exposure. So next time you step in front of a judge, remember, accountability isn't optional. It's the whole point. If you love seeing justice unfold live, hit that like, smash subscribe, and turn on the bell. Because we've got more courtroom showdowns that prove one thing. In this room, every lie leaves a trail.
Welcome to one of the most unpredictable courtroom moments you'll see today. Defense attorney Sam Bernstein steps up for Mr. Bloom, a defendant who's about to challenge everything from missing discovery files to alleged judicial bias. What starts as a simple scheduling turns into a heated exchange that spirals out of control. Will the judge keep control? Or will Mr. Bloom push too far? Stay tuned, because this courtroom gets tense fast.
And I'll leave that open and we'll get it done.
Okay. Jury final settlement conference will be set August 9th, 2024 at 9 a.m. Jury selection in this matter will be August 12th, 2024 at 8:30. Both of those proceedings are in person.
I'll let you go.
I was going to try to get you. I was going to try to get you out of the room. Bloom. I was trying to get you out of the room before you said anything. You knew what I was doing. That's why your finger went up.
At least I'm not driving with a suspended license.
I have no comment.
Okay. 2 times now I've let it go. Remember?
Let what go?
I said enjoy the day, enjoy your horse, all that. So I let it go. The time before that, I let it go. But Your Honor, today I need to put something on the record. This is very serious.
Put something on the record all the time. Go ahead.
Okay. No, not last time. Okay. Your Honor, this case, assault and battery case, has gone over a year. And since October, I've fought tooth and nail for discovery. I still haven't been given the hospital report, any photos, any, there's a lot missing from discovery still. Remember, since October, we've.
No, I remember you mentioning it, but hold on a second, Mr. Bloom. Has the discovery been requested, Mr.?
Yeah.
This is why, Mr. Bernstein.
Which discovery referencing, Jeff? hospital report that Deputy Soyring says there was a hospital report. There was, I'm wondering how this case was even brought about, Your Honor, because
Okay, Mr. Bloom,
there was never a report.
Mr. Bloom.
Okay, I'll let it go. I'll let my attorney.
Because you keep asking me questions you know I can't necessarily answer.
Okay, let me get on with the real stuff.
Oh, okay.
Per transcripts.
No,
I still haven't received the transcripts.
of what?
3/6. Remember I asked for the transcripts from 3/6? I still haven't received transcripts from 3/6. That's 3 months ago. I know it takes a while, especially this being a misdemeanor case.
Hang on. We have to have a written request for the transcripts. And Mr. Bloom, here's what I'm going to suggest. If you need those, again, you have an attorney, tell your attorney that's what you need.
Okay, well, this is my assistance of counsel, just like Ms. Barroso has assistance and you have assistance.
I don't have assistants. I have individuals that I work for that are professionals. So I don't know what you have, but I don't
professional
have
for real.
But go ahead.
I can clarify what Jeff's talking about. I ordered an audio recording of that hearing, and someone in my office we did a transcription of it for Jeff. But I think what he wants me to request is an actual transcript, and I just didn't.
And so they can do that, pay for it, and I'm sure it will be accomplished. But if we haven't received a written request for that, then that won't happen.
Now this is where things get heated. Mr. Bloom starts quoting judicial canons, actual ethical rules that judges must follow, accusing the court of possible ex parte communication. That's when a judge talks to one side privately, without the other party present. These are serious accusations, and in real-world courtrooms, making them without proof can escalate fast. But Bloom seems convinced the judge overstepped boundaries, referencing phone calls and notes that he claims shouldn't exist. You can feel the shift here. It's no longer about the case itself. It's about trust. Do you think Bloom's concerns are valid, or is he pushing his luck in front of a fed-up judge?
So,
thank you. Well, I ain't gonna go through all this. I just need to put a little bit on record. Per transcripts from 10-4, you stated that you believe everything a Washtenaw County Sheriff's 22. Washtenaw County Sheriff Deputy says is true. And you believe everything a Washtenaw County Sheriff's Deputy said.
Hold on a second. What are you reading to me right
now? Something that I want to state on record, Your Honor.
No, but what you're obviously stating what somebody else said. I'm just trying to figure out where it's coming.
You said
on the 24th of
on 10-4 of 22.
In this case?
No. You stated that you believe everything a Washtenaw County Sheriff's Deputy says, correct?
I don't recall saying that.
And you were upset that my attorney questions the deputy's authority of authenticity and requested said officer to be under oath. And there is proof that deputy testified with reckless disregard for truth. You were also misled on 9/13, 10/4, and 11/7.
Mr. Bloom, is this in regard to your other matter?
This is regard to everything.
Well, no, it can't be in regard to everything. It's got to be in regard to your other matter because this didn't start. No, stop. This case didn't start until 10/18. So if you're referring to a record from another case,
then I'm past that.
Then you're past what?
I'm past the other case. Here we go. This is this case. Canon 2, Canon 2A, Canon 3, which in part reads, a judge shall not initiate, permit, or consider ex parte communications or consider other communications concerning a pending or impending matter that are made outside the party's presence or their lawyer's presence. Canon 3A4B in part reads, not only is it a gross breach of the appearance of justice when the defendant's principal adversaries are given private access to the ear of the court. It is a dangerous procedure.
What are you, Mr. Bloom? I'm going to stop you because what are you talking about?
I'm talking about the transcripts from 3/6, Your Honor, where you stated you had notes, you stated you had a phone call from ex parte communicators.
No.
And just like that, the judge ends the hearing with a firm goodbye. This exchange perfectly shows how fast courtroom tension can escalate when frustration meets formality. Legally speaking, Mr. Bloom's questions about discovery and transcripts were fair, but accusing a judge of misconduct without evidence is risky. It can damage credibility or even lead to contempt. Still, this clip captures a real human moment in court. Frustration, pressure, and the delicate balance between defending your rights and respecting authority. If you found this courtroom showdown as intense as we did, make sure to like, share, and subscribe for more explosive courtroom breakdowns. And let us know in the comments. Was the judge right to shut it down, or did Mr. Bloom deserve to be heard?